Okay, I think we have a nice quorum. Good afternoon, everyone. Thank you for attending our webinar on FCPA enforcement trends and challenges and forecasts. My name is Daanish Hamid, and I'm joined today by my colleague, Jon Rosen. We are partners at PLG, a full-service law firm, and are based in Washington, D.C. We are part of our firm's white-collar and international trade practice groups. My practice focuses on anti-corruption investigations and compliance matters. Jon is a seasoned white-collar litigator who has served as a former federal and state prosecutor. Jon, maybe you'd like to say a few words of introduction.
Thank you, Daanish, and welcome everybody. I think the most salient point for at least today's presentation is that when I was an assistant U.S. attorney here in Washington, D.C., I was the lead prosecutor on behalf of my office for all fraud in Iraq during the post-war period in the 90s. So that was a pretty busy time with respect to the FCPA.
Fantastic. Well, before we start our presentation, we would like to note that we will be making these slides available to you after it concludes. Also, throughout this webinar, feel free to post any questions that you have in the chat room. We will endeavor to address those questions in real time, or if it makes better sense, at the end of the presentation. Also, if you encounter any technical difficulties, please email our marketing manager, Holland Goodrow. Her email address appears in the chat box. So let's get started. So during our webinar today, we will be discussing what lessons or themes can be gleaned from major FCPA corporate settlements that occurred in 2024, and there have been several. We'll also be addressing new policies and requirements implemented by the Department of Justice, also how corporate compliance programs and internal investigations may be impacted by those policy developments. And finally, we'll be sharing some predictions on whether FCPA enforcement will be materially impacted with the change in administration in Washington next week. And by way of a spoiler alert, we think that DOJ has laid the groundwork over the past couple of years to increase FCPA enforcement, notwithstanding any change in the administration. So Jon, maybe you could give us some highlights with respect to enforcement.
Great. Let me do that by beginning with a small caveat, everybody. Looking at FCPA enforcement year by year, well, it can be somewhat artificial. And the reason for that is simple. FCPA cases take a very, very long time. Let's take a look at two FCPA individual prosecutions in 2024. Those are for executives of an international waste company called Stericycle. These 2024 prosecutions arose out of a corporate settlement in 2022, which in turn related to alleged conduct that began in 2011 and lasted through 2016. So given the almost 13 years from the start of the alleged conduct to these two individual prosecutions that we've been seeing in 2024, and one of them still ongoing into 2025, it's really hard to make any particular judgment about the importance of a specific calendar year. However, because DOJ has been talking for a while about the importance of individual prosecutions, we can definitely see how these two individual prosecutions I just referenced form part of a long-term trend in gatekeeper liability, which is DOJ's emphasis on holding those who personify the company and do alleged behaviors that violate the FCPA or other criminal statutes, hold them accountable by putting their skin in the game, so to speak. So it may be more helpful to see FCPA enforcement in terms of trends rather than calendar years. And before I jump into those trends, let me highlight three overarching themes for today's discussion that I think might be helpful to structure what you're about to hear. First, penalties have become more complicated. As we'll discuss later on in 2023, DOJ made some important revisions to its corporate enforcement and voluntary self-disclosure policy known as the CEP. Now, those revisions allow a company that did not voluntarily self-disclose to still get a discount of up to 50% off its fines if they cooperate. Now, we get guidance from the DOJ, which is obviously helpful. They're announced with much fanfare. Usually the Deputy Attorney General may announce it. But sometimes it takes time to see how that guidance is actually being applied in the settlements. The proof is in the pudding, right? So this, the 2024, was the first calendar year since the DOJ issued that guidance. And I think that these settlements, we think that those settlements will be instructive. Speaking broadly, we're going to see ranges of 15 to 40% reductions in criminal fines. I'm going to talk specifically later on about the rationale that DOJ put forward and the rationale that we might extrapolate from their rationale as to why those varying percentages exist and where they were on the sliding scale for those companies. For now, though, I think the fact that the range is so great underscores the fact that calculating penalties has become more challenging and increasingly more important. After all, these fines amount to hundreds of millions of dollars. So the percentages we're talking about represent a lot of money. The second overarching theme I think that will inform today's talk is the government's expectations that compliance be proactive as opposed to reactive. The 2024 settlements, I think, make that clear. This means that companies seeking cooperation credit from DOJ should be thinking in advance about the risks which they face from their business operations, follow best investigative practices, do them without being asked, and demonstrate how their efforts yield information that the department could not otherwise have obtained on its own. It's really important to show DOJ, if you're in front of them and you're cooperating or attempting to cooperate, that you thought about the risks which inhere in your business operations. You document those risks and were proactive in trying to address them. Third overarching theme I want to emphasize is this. The ceiling has now become the floor. When it comes to 2024 remediation and 2025 compliance, we're going to see how 2024 sets the standard for the baseline in 2025 remediation. We're seeing companies in 2024 engage in major structural changes they do business, some including refusal to use third parties with respect to public contracts. Yet, despite those high levels of cooperation mediation, not a single company received full cooperation, that's 50% I referenced earlier, in any settlement. This is because DOJ expects companies to reach higher and higher levels of cooperation and compliance in 2025. In other words, the steps that the companies took in 2024 to cooperate is going to set the bar for what the DOJ is going to expect from companies now in 2025. So looking more broadly at these enforcement highlights, we see a lot of elements here. And Daanish, let me defer to you to begin discussion about the increase in U.S. enforcement.
Well, John, as you know, 2024 has been a fairly eventful year as far as FCPA enforcement activity is concerned. Both the Justice Department and the SEC have achieved some major enforcement milestones. In 2023, enforcement agencies collected over $900 million in settlement amounts from various companies. In contrast, that number more than doubled in 2024. Specifically, in 2024, enforcement agencies resolved about 11 different settlements with different companies and collected over $2 billion in settlement amounts. Of the 11 FCPA cases resolved in 2024, 5 of them yielded settlement amounts in the hundreds of millions of dollars each. Also, DOJ reaffirmed its commitment to hold individuals accountable for FCPA violations. In this respect, approximately 14 individuals, including senior officers and government officials, face prosecution for FCPA and related money laundering offenses in 2024. So this slide gives sort of an overview of the 11 companies that entered into settlements in 2024 to resolve their FCPA cases. The bribery schemes that got these companies in trouble involved a variety of countries, including Qatar, Ecuador, Panama, South Africa, India, and surprisingly, even Japan. And as is known, Japan is generally deemed to be less corrupt than the UK or the US, but a good reminder that corruption risk can arise even in the least suspecting circumstances and countries. Also, the industries in which these companies operate range significantly, include defense, aerospace, commodity trading, software, and international consulting. In terms of fines, of course, the most significant FCPA settlement in 2024 involved RTX Raytheon. That case also consisted of export control violations as well as fraud matters as well. The Raytheon case is also noteworthy with respect to the fact that DOJ imposed not one but 2 different compliance monitors on the companies. The use of monitors in FCPA cases has not been seen since the Glencore case that occurred back in 2022. And questions had been previously raised as to whether the use of monitors had gone out of style. And now we're seeing them returning. This next slide gives us sort of a summary of enforcement activity involving individuals. DOJ has made it clear over the past several years that it will aggressively hold individuals accountable for bribery offenses. In 2024, we saw approximately 14 individuals face FCPA-related prosecutions. In 2 of these cases, the CEOs of certain companies have been held accountable for FCPA violations. Also, in many of these cases, the individuals in questions were not even U.S. persons. Some of them were extradited to the United States to face charges. So this serves as a very strong reminder that long distances and international borders will not deter DOJ in its quest for justice if there's a sufficient U.S. nexus in relations to a bribery matter. Maybe, John, you could give us your thoughts on declinations under policies.
Great. Thank you. You know, the declinations that we're about to talk about now, well, they're very specific. They're occurring under the Corporate Enforcement Voluntary Self-Disclosure Program, known as CEP. Those are made public. The declinations that you might generally think about, well, you know, there's insufficient evidence, for example, so DOJ will say, sorry, we're not going to prosecute. Sorry to the agencies that are presenting, not to the companies, of course. Those declinations, right, those are not made public. So here we're talking about declining rate of declinations under the CEP. And as we can see in 2024, there was only one, which involved Boston Consulting Group. Let's talk about that in 3 specific ways for just a moment. Well, we're basing it on the letter that was sent by DOJ to BCG. 1, we're going to find the use of third parties, of course, the biggest risk factor in all of FCPA enforcement. Daanish, we'll talk about in just a moment. $4.3 million in commissions were paid to third-party consultants to get $22.5 million in business from the Angolan government. All in all, BCG earned $14.4 million in profits. What was really amazing about this one, though, was not just the use of third parties, kind of commonplace in FCPA settlements, is the extraordinarily high commissions that were paid. 20 to 35% of the value of any government contracts that were obtained. In addition, DOJ required disgorgement of about $14.4 million in profits. We're typically seeing DOJ use disgorgement in all of its cases now. I think the most salient part of the declination is the role of remediation. BCG required those culpable partners in Portugal that paid the funds to those consultants to give up their equity in the company. In addition, BCG withheld bonuses from its partners in Portugal who paid the bribes. And remember when I talked about ceiling and floor a bit later on, I think it'll be interesting to see how the DOJ leverages this equity surrendering to prove, and whether that becomes an emerging best practice to remediate wrongdoing. And I think we'll get into some of that later on when Daanish talks to us a bit about the ways in which DOJ is using compensation to punish those who are responsible and incentivize good compliance. So Daanish, if you don't mind talking about third parties now, that'd be great.
Sure. So as is well known, over the past several years, since the enactment of the FCPA, the majority of enforcement cases involve instances where third parties, such as agents, distributors, consultants, suppliers, or vendors, were used to support bribery schemes. In this respect, FCPA corporate settlements in 2024 were no different and continue to highlight the corruption risk that third-party relationships continue to pose for companies. So FCPA cases involving Raytheon, Trafigura, Telefonica, others, all involve third-party intermediaries. In the case of Telefonica, the company recruited 2 suppliers to pay bribes. The company financed those bribes by purchasing equipment at inflated prices from those suppliers. In the case of SAP, the company, through certain agents, engaged in a scheme to bribe South African and Indonesian officials to win business. In another case involving Gunvor, again, a good case that highlights third-party risk. Gunvor is part of DOJ's multi-year effort to hold several commodity trading companies accountable for bribery violations. This is part of DOJ's effort to take an industry-wide approach to pursuing prosecutions. Also, during a recent FCPA conference, a DOJ official observed that if DOJ identifies a third-party agent or an intermediary that has paid bribes on behalf of one company, DOJ will then seek to identify any other companies that use that same agent or intermediary. Then those other companies could become the target of a subpoena or investigation. And so there's a clustered approach to enforcement in this respect. Turning back to the Gunvor case, the company appears to have actively directed its intermediaries to pay bribes. In one case, the company directed its intermediary to purchase a very expensive Swiss watch for a corrupt government official. DOJ ended up not only holding Gunvor accountable under the FCPA, it also secured money laundering convictions against the company's intermediaries, as well as a certain corrupt official. With that in mind, Jon, maybe you could give us your insights on DOJ's heightened cooperation expectations.
Thank you, Daanish. On page 10 of our PowerPoint, we see that the government's expectations for cooperation, well, they've increased. And in short, the government's raised the ante for cooperation or mediation, and the government is expecting more. The reason why they're expecting more is because they're giving more. DOJ now, or they say they're giving more. They say that they, as I mentioned earlier, they can now offer up to 50% discounts and criminal penalties for cooperation from companies which do not self-disclose, among other things that we'll get into in just a bit. DOJ is clearly using the carrot of penalty discounts to incentivize companies to take even greater measures when it comes to cooperation and mediation. So let's examine these 2024 settlements to see if we can see this in practice. Daanish introduces the SAP case to us. That case involved a discount of 40%. As Daanish mentioned, and that was 40% discount in criminal penalties. Daanish mentioned it involved the reliance on third parties, the scheme. Let me just add also that some of those third parties did not provide any services at all. In addition, that scheme involved two third parties getting 14.9% commissions, which fell under the company policy requiring higher levels of approval for 15% commissions. DOJ credited SAP's cooperation because it imaged phones, and this enabled DOJ to get incriminating information it otherwise couldn't have gotten. It also credited SAP's remediation by eliminating the use of third-party sales commissions globally and prohibiting all sales commissions for public sector contracts in high-risk jurisdictions. With all the $109,000 in bonuses to relevant personnel, it expanded the data analytics capabilities in terms of its compliance. All that being done, why only 40%? By eliminating third-party commissions, SAP made major structural changes to its business. Yet 40%, it's not 50%. Clearly, DOJ wants to leave room for companies to do even more. And while it's not expressly stated in the press release, I think there's an aspect of deliberate ignorance that DOJ found somewhat dissatisfying when SAP was not flagging those 14.9% commissions that seemed manufactured to avoid the 15% trigger of review. Next on the spectrum is Gunvor, that Daanish talked about as part of an industry sweep of the national commodities trading companies. We also had reliance on third parties there. In this case, there was a 25% reduction in criminal penalties. DOJ credited cooperation, imaging phones, and remediation and elimination of third-party sales agents. And yet, Gunvor, right, got 25%. Why? Why not 40%? I think this is the part about reactive, proactive compliance I talked about at the jump. Here, it's important to note that starting in 2018, Gunvor senior executives and people in the legal and compliance made inquiries from third parties concerning the lack of documentation regarding these transfers that turned out to be bribes, and asked for them to meet with Gunvor officials to discuss their activities. And third parties resisted these requests. It took nearly 2 years for Gunvor to terminate the relationship. In fact, even while third parties were resisting Gunvor, still paid them. They continued to pay and execute the kind of payments that were in support of the bribery schemes. This is reactive compliance. And it's something that DOJ punished Gunvor for. It was not seen in the SAP case. So going down the line now, we're going to get to Telefonica. And of course, Daanish mentioned that one and the relevance of third parties in the execution of that scheme. This was a 20% reduction in criminal penalties. And it was cooperation, remediation, disciplining employees, and so forth that DOJ cited. But why 20%? Well, DOJ told us the company, failed to preserve relevant evidence for DOJ. In the initial phases of the Department investigation, they failed to identify, collect, and produce certain records and important information, according to DOJ, which affected the investigative efforts of the Department of Justice. Going further down the line, we have Trafigura. That got a 10% discount in criminal penalties. In this case, as Daanish mentioned, there was some reliance on third parties. It's incredible to note that there was no due diligence on these third-party agents. Trafigura hired a former government official that was actually involved in the bribery to be its agent. And it used Singapore-based intermediaries to assist in the conduct of the Brazilian-based work, which begs the question, what's the connection between Singapore and Brazil here? I think the government saw all of that, credited the cooperation, credited some of the remediation, but was left feeling like something was wanting. What was that? Well, again, here DOJ told us. Delayed cooperation. They cooperated after they decided to cooperate, but it took them a little while. During the early phase of the investigation, Trafigura failed to preserve evidence. DOJ noted that. It took positions that were inconsistent with full cooperation during the early phase of the investigation. Now, that's a warning shot to people like Daanish and myself, for company counsel, I think, who the government believes may be overly zealous in negotiating and advocating. The government also delayed remediation. It was delay in exercising disciplinary actions for employees, which can be troubling because it can take some time for companies to conclude that there was wrongdoing and that it warrants discipline, especially under the local rules, local privacy laws in which they're operating in foreign offshore jurisdictions. So this is a case of watch what I say, not what I do. DOJ and SEC will always tell you, me, I can't tell you the number of times it's been said, that, well, we're not telling you in the company what to do when it comes to your employment decisions, your administration. But here we can see that DOJ will take that into account, as they usually do. Another aspect of the thing that caused only 10% credit is the fact that there was recidivism. DOJ felt probably that this company did not have clean hands. So we can see, as we go on the scale, the most proactive to the least proactive, to actually having your lawyers go in front of DOJ, not hand over relevant material, and actually say things that are inconsistent with cooperation and delay things. That's the last case. I think we can see the relevance of proactive and reactive cooperation when it comes to actually generating credit. Daanish, would you kindly go to the next bullet in terms of international cooperation?
Yeah, so international cooperation between DOJ and enforcement agencies in other countries, it's been around for a long time. It started obviously with the OECD Anti-Bribery Convention and then several other conventions as well. But more recently, DOJ has led some initiatives to strengthen its relationship with foreign enforcement agencies. And DOJ has claimed that such cooperation has assisted in collecting evidence, facilitating extraditions, and making witnesses more available. So it is through international cooperation that foreign enforcement agencies have enhanced their own prosecution of corruption offenses. And we've seen this in surprising jurisdictions such as France, for instance, which has become very active in the anti-corruption enforcement space. 2024 has also shown that companies that have committed bribery offenses in one country continue to face the risk of prosecution in other jurisdictions based on the same acts. We saw this in the Gunvor case. In that case, the company paid fines not only in the United States, but it also faced millions of dollars worth of liability in Switzerland, where its headquarters is located, as well as in Ecuador, where the bribes were paid. In multi-jurisdictional liability was also an issue in other FCPA cases involving Trafigura, McKinsey, and SAP. Maybe switching some more gears here, John, maybe we could go back to discussing policy trends, enforcement trends, especially with respect to cyber incident response plans.
Yeah, let me do that. And what we're really specifically talking about now is the SEC. The FCPA has accounting provisions that are independent transactionally with respect to the anti-bribery provisions. We've been talking about that a lot, right? But the FCPA also has these rules that require issuers to keep accurate books and records that reflect the transaction dispositions of the assets of an issuer, as well as rules regarding internal controls that will provide some reasonable assurances that those transactions are executed in accordance with management's authorization. Let's call those accounting provisions because they're not anti-bribery per se. There's no element here about quid pro quo. Why do those rules exist? Well, the rules exist because they're there to protect shareholders, remember, we're talking about issuers, from accounting fraud by ensuring that shareholders receive an accurate assessment of the company's expenditures. This is consistent with the use of the FCPA in commercial litigation, securities class actions by shareholders claiming to have purchased their shares at an inflated price, derivative actions brought by shareholders on behalf of the company to recover the loss associated with misappropriated funds. We've been seeing recently, both DOJ and SEC can enforce these accounting provisions, but we've been seeing recently the SEC is bringing standalone cases, meaning without DOJ, where there may be insufficient evidence of foreign bribery, or the case in DOJ's opinion otherwise lacks egregious misconduct. And what we're seeing most recently in 2024 was an expansion of the liability under these accounting provisions, where the SEC is bringing these standalone cases based on facts that seem unrelated to the kind of accounting fraud concerns which gave rise to the rules in the first place. Let's take a look at the R&R Donnelly and Sons case, which is on the PowerPoint here. A global provider of business communications and marketing service, well, they settled an FCPA matter with the SEC in 2024. What was the alleged basis for that? Well, that was the failure to protect against cyber attacks. So what we're seeing now is that SEC is applying its accounting provisions to require internal controls that will not fail to prevent or detect any accounting misstep. Cybersecurity, to me at least, seems a bit unrelated to accounting fraud. Will training of employees soon come under SEC enforcement? Is this an example of government overregulation, which would be a separate seminar that hopefully Daanish and I can invite you to at some point? Seems here the SEC may be arbitrarily interpreting this regulation to punish conduct where no offense even occurred. And the SEC is able to cherry pick its cases. There's a high probability of settlement, which means all of this is occurring without the kind of checks and balances that judicial oversight is intended to represent. So with that in mind, let's pivot now to the DOJ policy developments. That's on page 17 of our PowerPoint. And just to briefly provide some context here, we live in an age of disclosure. Regulated entities are all across the spectrum in business, from Sarbanes-Oxley to federal acquisition regulators for government contractors, bank secrecy acts for financial institutions. These regulated entities, among others, must disclose certain wrongdoing to the government when they identify it. Sentencing guidelines offer companies substantial reductions in fines for companies that self-disclose. So they reduce the penalties. And given the elastic quality of corporate criminal liability, reducing penalties is pretty important. Companies face exposure, particularly when regulators are over-criminalizing business conduct. Government has a lot of leverage over companies who may find themselves as a subject of investigation. 2024, we're seeing DOJ up the ante a bit by making changes to its corporate enforcement policies to incentivize greater disclosure. Among other things, they're paying for information from individuals. Prosecutors typically don't do that, obviously, for reasons I'll get into in just a bit. They're also offering non-prosecution agreements, NPAs, to individuals up front. And you typically do that. Why? Why are they doing that? To encourage individuals to come forward, to get more leads on individual cases. I think the real reason is associated, but not entirely like that. Semantically, I'd say it's to force companies to come forward quicker because they may be more afraid that a whistleblower is going to blow the whistle. And ironically, at the same time, do these same policy changes actually simplify a company's decision to come forward or make it more complicated? The new rules that we're about to talk about condition those benefits in certain ways that the company will not likely know at the time of any self-disclosure that they've met. Because these offenses involve offshore conduct, right? It can take some time to determine whether an FCPA violation actually occurred, let alone determine the full scope of it, whether management was involved, so which ones, what level of the C-suite, and determine its pervasiveness, not only in the business unit in which the offense occurred, allegedly, but any of the other business units that have similarly situated structures. So the question really is, does the company take the time to investigate these issues and risk a subpoena from DOJ because the whistleblower blew the whistle, or rush to DOJ hoping that, gee, everything will work out for the best? So let's learn more about these policy developments and then revisit these questions at the end. And I think, Daanish, you're going to begin with the individual whistleblower programs and FCPA, please.
That's right, John. Effective April 2024, DOJ implemented a pilot program on voluntary self-disclosure for individuals. Pursuant to that program, the criminal division of DOJ has instructed prosecutors to consider offering non-prosecution agreements to individuals who voluntarily disclose original information about certain types of criminal misconduct, including providing a complete account of their own role in that misconduct. Also, in order to qualify for the program, those individuals must fully cooperate with authorities and pay applicable victim compensation. Now, the program is limited to certain types of criminal conduct, and those include violations by financial institutions, including money laundering and fraud, foreign corruption and bribery, including FCPA, FCPA, and anti-money laundering violations, healthcare and other types of fraud, and then finally domestic bribery and kickbacks. And we're seeing a trend here that involves DOJ now focusing more and more on U.S. bribery activity, and this is part of that effort. DOJ has declared that one of the purposes behind this program is to incentivize companies to create compliance programs that encourage robust internal reporting of complaints. Of course, there are multiple conditions that an individual must satisfy pursuant to this program to qualify, ensuring that disclosures are voluntary and based on original information. Also, as mentioned before, they must provide full cooperation. The scope of full cooperation can be pretty subjective. This program is available only to certain individuals. There are other types that are excluded from the benefits of the program, including company CEOs and CFOs, as well as organizers and leaders of the criminal scheme. Another sort of policy development or statutory development that we've been monitoring is the Foreign Extortion Prevention Act, or FCPA. So in 2023, Congress passed FCPA and then amended it in 2024. This law criminalizes demand-side bribery. In other words, bribes that are requested or received by government officials, including foreign government officials. A violation of FCPA will occur if a foreign official solicits a bribe from someone associated with the company incorporated or listed in the United States. A violation of FCPA may also occur if a foreign official or its agent solicits a bribe from any person while the official or its agent are in the United States. So while the FCPA focuses on supply-side bribery and not demand-side bribery, FCPA addresses that gap that has been around for some time. Of course, prior to FCPA, and with respect to ongoing cases, DOJ prosecutes government officials under anti-money laundering statutes. Satisfying the evidentiary standard under anti-money laundering laws can sometimes present challenges, and presumably FCPA will help ease the prosecution of corrupt government officials. In addition to that, information that DOJ receives in the course of FCPA investigations can be leveraged in order to pursue FCPA investigations against parties that actually provide the bribes. So FCPA and the FCPA are intended to complement one another. And this is why in March of 2024, DOJ announced that its FCPA unit will be handling cases under FCPA. At the end of the day, FCPA is still a relatively new statute, and its impact is yet to be assessed, but again, something for us to continue to monitor. Another policy development involves a separate whistleblowers award pilot program that was issued in August of 2024. So for many years, of course, the SEC has maintained a whistleblower incentive program pursuant to the Dodd-Frank Act. That program focuses on providing financial rewards to whistleblowers who report securities violations, including violations of the accounting provisions of the FCPA. However, the SEC program has a limited scope. It's limited and it's only available in the context of violations committed by public companies and other issuers. The SEC program does not apply to FCPA and other legal violations committed by privately held companies or domestic concerns. In August of 2024, DOJ announced its own whistleblower pilot program that seeks to address this gap. Under the DOJ program, an individual can qualify for a financial reward if they provide DOJ with original information in writing that leads to a forfeiture exceeding $1 million in connection with a prosecution, resolution, or forfeiture action related to foreign corruption, domestic bribery, financial institution crimes, or certain healthcare fraud. Of course, this description is fairly high level. This pilot program contains numerous detailed conditions that must be satisfied by a whistleblower before they qualify for a reward. One of those conditions is that the whistleblower must generally have clean hands. So in this respect, the DOJ program is more demanding than the SEC program. Employees who use corporate internal reporting systems prior to notifying DOJ can earn an increased award under this pilot program. However, employees will not be eligible for a DOJ award if they failed to report to DOJ within 120 days of making an internal report within the company system. The whistleblower pilot program was simultaneously announced with related revisions to the Corporate Enforcement and Voluntary Self-Disclosure Policy, or CEP. CEP has a temporary amendment that allows presumption of a declination for a company if that company self-discloses an issue to DOJ within 120 days of receiving an internal report from the whistleblower. So this interplay between the CEP and the whistleblower pilot program is clearly intended to drive companies to self-disclose violations to the DOJ. However, as many of us know, voluntary disclosures involve a very difficult calculation. You must weigh a variety of factors, and it's unlikely that 120 days is enough time for a company to make an informed decision. This is something that Jon highlighted before. Also, questions still remain as to whether the whistleblower pilot program undermines corporate compliance programs. There's nothing to prevent a whistleblower under this pilot program from going directly to DOJ rather than using a company's internal reporting system. So during a recent FCPA conference, DOJ officials announced that in their view, the whistleblower pilot program has already been successful. DOJ has reported that it's received over 250 allegations from whistleblowers, and it's currently in the process of scoping and investigating 60 cases. It's not clear at this stage as to how many of those cases involve the FCPA, but maybe, Jon, you could share some insights from your end.
Yeah, I'd love to, because I think that the whistleblower program that Daanish, you were just talking about, is a little problematic from an execution perspective. Why is that? Well, we know, because DOJ tells us, that the whistleblower will not be personally involved in the misconduct, will not be truly culpable. There are some exclusions that have some nebulous standards to how they're going to be enforced. But the gist of it is no clean hands. They will not take people who are culpable. And what that means is disclosures under this program will likely be based on secondhand information. In other words, the quality of information that DOJ is going to be getting from these whistleblowers that are going to come out of the woodwork may be suspect. And then they're paying for this information. So they're creating this impeachment up front, which is, by paying for information, undermining the whistleblower's credibility. It makes it really tough for these individuals to actually testify in court if these cases go to trial. But DOJ knows this. It's just a pilot program, and they're testing it out. And I think the reason why it will prove to be successful, despite all the issues I just identified, is they're not really not interested in taking these whistleblowers to court. The issue here, in my view, in our view, I think, is not to generate leads from whistleblowers themselves, but to get those those leads or to threaten the existence of those leads prospectively from the company's perspective in order to compel companies to make more self-disclosures. The DOJ, if it gets a report from the whistleblower, will issue a subpoena. Then those companies are going to come forward more likely with certain information. Or the company will act before they get that subpoena, fearing the subpoena is on its way. Either way, the DOJ is getting the information. That's when DOJ can establish its own narrative independent of whatever the whistleblower said. So their case ultimately won't depend on the whistleblowers. What we're seeing sacrificing individual prosecutions, if you will, in favor of more corporate prosecutions. Because you see, corporate resolutions, well, they're the bread and butter of what DOJ does. Makes sense. They generate the biggest bucks in settlements. In these cases, really go to trial. They generate the greatest buzz. In addition to the interest of justice, getting buzz, that's what motivates individual prosecutors. So there's no harm, no foul in paying for information. Well, if they're going to pay for information from whistleblowers, we'll never see a courtroom. That may not actually be a problem. That's the pilot. That's what they're testing in our view. See how it works out. I do think subpoenas are going to be flying. I think companies fearing that might actually come forward more quickly. Which gets us to this next PowerPoint, the changes in CEP, regarding corporate disclosure. We've talked about some, but there are some new ones in August 2024. Remember when we talked about 50%? That was 2023. Speaking about long-term trends or longer-term trends, we're going back some years, or at least in that case, 1 year. But now let's talk about 2024 specifically, okay? Because what DOJ did is it expanded the presumption of a declination and offered new incentives to companies to self-disclose. As we can see under the prior rule, the company that self-disclosed without aggravating circumstances received a presumption of declination if it satisfied the conditions you can see here: timely, full cooperation, remediation. And the aggravating circumstances, those that are identified here. There's a new rule that, as Daanish mentioned, keeps a presumption of declination for a company that self-discloses if it's done with 120 days of an internal report. Why is that a change? Well, you remember there had to be a voluntary disclosure under the old rule. But in the old rule, DOJ would have treated a corporate self-report following an internal escalation in which the whistleblower expresses an intention to report to DOJ. Well, they would have said to the company, you've received that, therefore your corporate self-disclosure now is not voluntary. It's no longer the case. As Daanish adroitly mentioned, government is really sensitive to trying not to undermine internal investigations and internal compliance. That's an example of that. Going down the sliding scale, which is what this chart does, we now see a possible declination being offered under these changes to a company that self-discloses despite having aggravating circumstances. And we see some requirements here. If the disclosure is immediate, if the company implements an effective internal compliance, strike that. If the company had implemented, meaning at the time of the misconduct, they had an effective internal compliance program. This is not about remediation. This is a post hoc judgment. Company engaged in extraordinary cooperation in remediation. That's another element. Going down the sliding scale, we're no longer talking about declinations. We're talking about companies getting prosecuted. If a company self-discloses with aggravating circumstances and meets other circumstances, they can get up to 75% discount. So there's your carrot. You may not know if you have aggravating circumstances, but if you do and we prosecute you, you're going to get an additional potential 25% off because the baseline, as we pivot to the final change, that's from 2023, allows for a 50% discount. So let's just revisit this company's decision to cooperate. I think it's become more complex. How can a company know if aggravating circumstances exist or not if the disclosure must be made immediately, i.e. within weeks of learning of the misconduct? But hey, does it really matter? They might get that extra 25%. Really? Well, how can they confidently conclude that DOJ is going to view its compliance program as effective in the face of a criminal allegation if they determine it's not? And this isn't a cordial company, recidivist behavior theoretically, you could get that additional 25%. You might find yourself back to that 10% level. And by the way, what is extraordinary cooperation? I want to present the credibility that's commensurate with the level of participants here in your involvement in this area. I do not know what extraordinary cooperation is. I doubt that anyone in DOJ does, but I do know why they say that, I think, because they want it to be unknown, because they want you to reach as high as possible. So I think it's become more complicated. I'm not saying companies shouldn't self-disclose. I'm just saying these policies that create greater carrots, give you greater incentives, give companies greater incentives. Those incentives may become academic if the conditions are not met in order to actually realize those gains. Let's pivot now to corporate compliance with the time that we have, and then we'll get some predictions. That gets us to, I think, page 24 of our PowerPoint. And here I just want to provide a brief overview of what DOJ is looking for when it comes to compliance. They look at this from two perspectives. One, has the company provided all relevant evidence related to the government's investigation? Well, we've seen that, right, in the prior 2024 investigations, settlements I talked about. In this age of disclosure, the government has basically deputized company counsel of cooperating companies to do the job up front, gather the relevant facts. And if you haven't done that because the facts don't exist, because the company didn't preserve it, that's going to impact the government's judgment about you and the company, that is, and whether a monitor should be in place. The second perspective is, has the company adopted policies and procedures which enabled criminal conduct? So meeting these DOJ expectations, again, back to the original theme, one of the original themes we talked about, is being proactive. Think about these issues on the front end. DOJ knows that compliance is not 100% guarantee that misconduct will not occur. The key is to show the government that, well, you're making your best effort. So, for example, you can have all the audit rights in the contracts. And the third-party agents, for example, flow down, they may deny your attempt to exercise those audit rights. But it's important to DOJ that you tried, to document that you tried. Here's what we did in response to their denial. Maybe you changed vendors. This means creating a narrative, having a narrative to tell the government if and when the time comes. What is your policy? Why is that your policy? What kinds of data did you rely on in formulating that policy? And how did you review its effectiveness? These are the core principles that will impact compliance generally in the things we're about to talk about next, which are the top compliance issues in our view of 2024, compensation and ephemeral messaging. Daanish, would you tackle the compensation for us, please?
Absolutely. And so over the past few years, DOJ has highlighted the importance of companies implementing employee and executive compensation incentives and clawbacks in an effort to encourage FCPA and related compliance. So this level of individual accountability was reinforced more recently in 2023 when DOJ launched its compliance clawback pilot program. That program requires the DOJ as part of corporate resolutions to require companies to account for employee commitments to compliance as part of a compensation and bonus determination system. Also, the pilot program provides fine reductions to companies that recoup or claw back compensation from employees who have committed violations. So we've seen fine reductions under the pilot program made available in recent FCPA cases such as SAP and Albemarle. More recently, in August 2024, DOJ reaffirmed its interest in compensation clawbacks in its revisions to the guidance on the evaluation of corporate compliance programs, or ECCP. So what this all means is that when evaluating compliance programs, prosecutors will review whether there are compensation systems that promote compliance and enable clawbacks. This is now an important factor that is accounted for as part of the enforcement strategy. DOJ's messaging on compensation and clawbacks is fairly explicit. DOJ expects companies to use compensation incentives and clawbacks as a carrot and stick to motivate employees to adhere to effective compliance standards. Employees need to understand that a company can seek to recoup compensation if they engage in criminal misconduct. And as for those employees who promote and ensure compliance, they need to be rewarded for those efforts so that they serve as strong examples to others in the corporate infrastructure. Jon, maybe you could share some thoughts on the role of ephemeral messaging.
Thank you. So DOJ is now considering assessing a company's compliance program in terms of a company's use of devices for ephemeral messaging and its retention of those electronic messages. Here are some key metrics. First, do company policies make business-related data accessible and amenable to preservation? DOJ is looking for the evidence. DOJ finds that you don't have it. The next question is, why not? They're going to ask, what was the policy environment where the evidence was dissipated? In order to get cooperation credit, you have to have answers to that question. You have to show that those answers reflect some risk-based approach to your company's business needs. Second, does non-accessibility impair a company's ability to conduct appropriate investigations? Here, DOJ is essentially going to look to see if the company is acting like an ostrich with its head in the sand. Oh, we couldn't get those messages last time when we were investigating. That was a roadblock. We did nothing about it, and guess what? It's occurred. They are gonna ask those questions, and if it turns out that it's had some previous obstructions in the company's ability to actually affect its compliance by running appropriate investigations, the company will get dinged. Third, the kind of notice that the company gives to its employees, and this is important. I say everything's important. I don't mean to be redundant, but this really is. The consequences faced by those who violated company policy. What they're really looking for is to see if the company's program is a paper program. So let's go to the next slide. The key areas of DOJ scrutiny in assessing these questions are going to be communication channels. Well, what type of electronic channels do the companies use to conduct business? Do they vary among countries, business lines? They focus exclusively on supply chain, or they go supply chain and warehouse and logistics? What are the mechanisms that the company has in place for retaining data in all of these communication channels? Policy environment is another area. What are the policies that are in place, the rationale? Are they workable? And are they being enforced? And as I mentioned, risk management. They're looking to see when it comes to compliance. They know one size won't fits all. So they're looking to see what was the particular path that the company took and why. So what I want to do is I want to break some of that stuff down in the next slide, specifically with respect to policies and procedures on page 29, slide 29. Here, DOJ is going to be asking about the policy and procedures regarding messaging apps, document retention, investigation protocol to obtain those messaging communications during investigation, an employee handbook to lay out those expectations, and look to see if there's a policy and procedure that covers those things. It's imperative for the company to find out who is going to likely have relevant evidence. And if the company can get 50% cooperation credit if it can identify relevant evidence, well, that's the best way to beat down the penalty. It's just to preserve and produce the evidence if the company decides to cooperate. It's also critical for the company to set the right tone at the jump. It helps the company avoid a monitor, as we've seen, that may be recurring. Has the company conducted a gaps analysis and documented its results to explain why the policies are what they are? Remember, this is a risk-based approach to compliance. And the government is expecting companies to engage in that gaps analysis and document it. What are the business countries with the greatest risk of foreign bribery? How do they communicate? Does the company use all levers to identify and communicate its policies? IT, HR, privacy, cyber, legal, corporate, regional, country heads, training, internal audit. These people are all assets, and the government's going to look at you and ask, are you looking at this bureaucratically in some silo, or are you more holistically engaging all the resources that are available to you, which can be important? IT can identify relevant custodians. HR can help in advanced consent. Privacy helps navigating local privacy laws to make sure that those consents are acceptable. Legal compliance makes sure you don't have the ostrich with the head in the sand because you've looked at past investigations, you saw what was successful or not, you did a post-mortem, and you remediated the kind of problems you faced in the past. Corporate can make sure that any communications policy is part of an integration plan. Regional country heads, well, they can get feedback on policy changes and get their buy-in before you actually export it out to other countries. Otherwise, you're going to operate as a silo, which will not be viewed favorably by DOJ training. They can be your eyes and ears because in training, employees say, we communicate through WhatsApp. We don't use that at the corporate platform. They can hear that and they can report it back. So these are just some important things to think about when it comes to policies and procedures. I'm going to, given time, I'm going to pivot to the next slide, page 30, which is the document preservation and retention. What does a company do to preserve communications for each of these different corporate channels? Preservation is critical because the scope of an investigation will change based on the facts. Now, I know lawyers we're scared that they're going to engage in a fishing expedition, and that's a righteous concern. But it's also true that we have to dynamically review what's being investigated to see if custodians who were not previously determined as relevant are now relevant. Because if they become relevant, now they're actually vendors brought on board and a third party and did not have government-facing responsibilities, and now they do. It's an FCPA investigation. The government's going to say, but they're speaking with the government. And we're going to say, well, were they on board or they weren't? And they're going to say to us, well, that's pretty lame. So that's why we have to make sure that we're doing this dynamically in revisiting scope. Consider an enterprise system to enable company employees to communicate on a corporate platform. Like an email server, all those communications, a company would have full access to. WhatsApp, for example, allows for enterprise communications at the corporate level. And these are some things that you can think about if, one, it's consistent with local laws, two, if it's economically feasible, and consistent with your risk profile. Litigation holes that identify ephemeral messaging tell as being something subject to that hold and instructs custodians to turn off auto delete. These are things that I think the government will be expecting. Finally, notice and discipline. What does the company do? And this puts us on to slide 31. What is it that the company is doing to put employees on notice of the communications policies? Make sure that the employees know the requirements to preserve communications relate to communications with third parties. Heck, make sure they know what the policy is. You know, one of the worst things that can happen is the government starts bringing people in. Government says, so what was the company policy and procedure with respect to the ephemeral messaging that was used in this case? And the employee says, what? What are you talking about? We had a policy on that? That's bad. Okay, so we want to make sure that doesn't happen to any company that we represent. With the time left, let's pivot forward, Daanish, if you don't mind, to predictions, shall we?
Save the best for the last.
Okay.
So go ahead, Jon.
All right. Well, I'm not Nostradamus. My wife will tell you that too. But I'll tell you what I think, what we think. Past is prologue. FCPA enforcement was generally higher in Trump 1 than the Biden administration. We believe it will continue. That it will continue to be a higher priority. You know, FCPA, when you think about it, deals with covert payments, which implicates potential terrorist funding. It's just a lack of transparency in the ways in which financial institutions are used to facilitate bribe payments, and that implicates national security. So yeah, DOJ will prioritize immigration, public safety. We know these things, right? It's also going to prioritize FCPA, we think, and export control enforcement as a matter of national security. We think the Trump administration will combat all forms of illicit finance and international finance systems, including commercial bribery. We also think that there's a possibility that line prosecutors will have more autonomy to investigate and prosecute cases. Less supervisory oversight means more freedom to bring those cases more quickly. Another aspect here is budget. I think budget concerns. Many DOJ programs, like the Victim Witness Fund, well, that's paid for by DOJ settlements. Certainly, public prosecutors are interested in pursuit of justice. They're also interested in satisfying certain baseline qualities by which they're measured for effectiveness. And the department itself does have a budget that is self-financed. I think that's part, and these settlements in the FCPA cases, well, they dwarf 99% of the other kind of settlements that come in other cases, including healthcare fraud. Funny, I think that there's a chance that FCPA and EPA and FIPA, excuse me, can be used to achieve some foreign policy or trade goals with China or other countries that are perceived as acting adverse to the United States' interests. So there'll be some threatened use of the FCPA, perhaps to ratchet up some compliance on some other front, which might be more of a political issue than a legal. Daanish, what are your thoughts there?
Yeah, it was pretty interesting during President Trump's first term. Around that time, he had described the FCPA as a horrible law that puts U.S. businesses at a disadvantage. And so the FCPA bars certainly started speculating as to whether that would impact FCPA enforcement. And it ended up not occurring along those lines. And it didn't, that type of view that the president had at the time did not deter DOJ and SEC to achieve some major FCPA settlements during President Trump's first term, as you mentioned, John. And so that was very interesting. And then also, when one looks at the list of companies that have faced FCPA enforcement, a significant number of them over X number of years since the FCPA was enacted, a lot of them are headquartered outside the United States. So in this respect, an argument could certainly be made that U.S. enforcement agencies have been using the FCPA to level the business playing field, if you will, for compliant U.S. companies that are competing with corrupt foreign ones. And so that element might actually be appealing to policy experts in the Trump administration, and could also explain, at least I'm speculating here, but could explain why FCPA enforcement did not experience a dip during President Trump's first term. With respect to the second term that's coming up, and as of next Monday, there have been no loud proclamations against the FCPA from President Trump's mouth as there were the first time around. So that's pretty interesting. And I certainly do agree with you that there is a national security angle to FCPA enforcement that could actually be leveraged. So instead, of focusing on criticizing the FCPA, the focus right now is on tariffs, and perhaps FCPA and FIPA prosecutions, especially against foreign parties, can actually be leveraged to promote Trump's trade policies. So I certainly am fully aligned with you, John, on that front. I think the one question that I have personally is, and the one area to watch, is whether the recent DOJ pilot programs, including those with respect to whistleblowers, will be continued after their initial term, which is for 3 years, and that spills over into the upcoming administration. Perhaps those programs can be impacted by the new administration, but again, I have to caution folks. I mean, there have been no announcements for or against those whistleblower programs, and those programs are relatively new. And then I think the last point that I want to make, relates to statute of limitations. And even if, let's say, there is less of an emphasis on enforcement, we have to also note that the FCPA has a statute of limitations of 5 years, and that period could actually be told for up to 8 years. The next administration's term is for 4 years, and so these statute of limitations could outlast the next 4 years of a second Trump term. And so that could also be a factor that could help sort of level any concerns as far as less enforcement on the horizon. But let's see. But in any case, John, any additional thoughts on that? Nuggets of wisdom?
No, I think you nailed it. I'm sensitive to time, and I'm just very grateful that I've had this opportunity to speak with everybody.
Well, that wraps up our presentation, and I am looking in our Q&A file, and I don't think I see any questions. But if anyone has questions for John or for me, our email address and our bios appear in the slides themselves, which again, we will be sharing with you. So feel free to reach out to either or both of us with your questions, and we'd be more than happy to address them. And again, thank you very much for joining us today. It's been fun. And John, thank you for your insights on all of this.
Thank you. It's been fun.
Very good. Have a good afternoon, everyone. Take care.